Hi everyone. Welcome and thank you all for joining us for day 2 of the Blockchain, FinTech and the Law Conference. My name is Alice Tranter-Wilson and I'm the Vice President of the Harvard Law School Blockchain and FinTech Initiative. I was a financial services lawyer back in Sydney, Australia, and blockchain is what really drew me into the tech law space. And studying an LLM degree at Harvard. So today I am very excited to introduce you to our panel who are going to be exploring blockchain regulatory and legal issues. So without further ado, joining us today, first of all, we have Jeff Engerman. Jeff is a partner at Gunderson Dettmer. His practice focuses on the representation of private and publicly held emerging growth companies. Jeff specializes in all areas of corporate securities and partnership law, with his work spanning the entire corporate life cycle. Jeff is also an active participant in the venture law community, and he currently co-chairs the Venture Capital and Emerging Companies Committee of the Boston Bar Association. Jeff holds a JD from Harvard Law School and a BA in American Studies from the Evergreen State College. Our next panelist today is Christina Spiliakos. Christina is a regulatory counsel at crypto finance company Circle, where she works on banking, securities, and state licensing matters related to Circle's products. Christina has been at Circle for nearly 5 years, starting as a legal and compliance intern during law school and continuing as regulatory counsel. Prior to Circle, Christina worked at the Massachusetts Attorney General's Office, Civil Rights Division, as well as the Massachusetts State Treasurer's Office of Debt Management Department, and the offices of 2 US state senators in Massachusetts. She holds a JD from Boston College Law School and a BA in Political Science and French from Boston College. Our next panelist is Michael Welsh. Michael is an associate at Cooley. His practice focuses on securities enforcement matters, complex civil litigation, and governmental investigations. He has extensive experience representing cryptocurrency exchanges, investors, and blockchain developers under investigation by the SEC, the CFTC, the Department of Justice, and other federal and state authorities. Michael holds a JD cum laude from Boston College Law School and a BA from Bowdoin College. And our final panelist today is Nimit Sawhney. Nimit is co-founder and CEO of Voatz Inc., an elections platform that uses biometrics, cryptography, and blockchain technology to enable voting via smartphones and tablets. Nimit's background is in mobile security and development, and he holds a master's from Carnegie Mellon in computer science, electrical engineering, and business management. Finally, our moderator for today is Dr. Pip Ryan. Pip is a barrister and senior lecturer in the Faculty of Law at the University of Technology, Sydney. In July 2019, she will join the College of Law at the Australian National University in Canberra. Pip is on the editorial board of Stanford's Journal of Blockchain Law and Policy and the chair of the Standards Australia Blockchain Technical Committee's working group for smart contracts. Her research currently explores the automation of trust, the accountability of algorithms, and the creeping tendency of regulators in developed economies to blame professionals, service providers, and financial institutions for the sins of their customers and nefarious strangers. Pip recently co-authored Blockchain Transforming Your Business and Our World, and her forthcoming title is Trust and Distrust in Digital Economies. Pip holds an LLB from the University of Technology, Sydney, a BA, a Master's of Education, and a PhD in Law from the University of Sydney. So thank you again, everyone, for joining us today, and I'll turn it over to Pip.
Thank you, Alice. Like all good barristers, I'm removing the water from the bar table. So when you go to the bar, don't have water on the bar table. You're all forgiven for now. And the second thing I just wanted to do was just let you know that when you've got your friendly witnesses, assuming these are all my clients, and you want to examine them in chief, you start with some questions that are really unintimidating. So don't ever say to your client when they're in the witness box, your name is Michael Smith, isn't it? The answer is the question is, what is your name? You get them to speak. So, rapid fire, I'm going to pass the microphone down, and the questions are going to be as follows. They've got to answer all four and then leave the microphone with Nimit, please. We're going to start with New York or London, and then what are you reading at the moment? Are you talking or listening? And what is your favourite mobile app? So, I'm handing over to Jeff, then Christina, then Mike, and then Nimit. Go. New York or London?
New York.
What are you reading at the moment?
A stack of contracts for venture capital firms putting money into blockchain companies. Multiple.
More power to you. Talking or listening?
Talking. No one pays me to listen. So
Is anyone listening? No,
yes,
don't worry.
that's up to them. If they're going to pay, it's up to them.
And your favourite mobile app?
Whatever I can run on my BlackBerry, my ancient, old, decrepit BlackBerry.
Christina, New York or London?
London. I lived in London for a year. Love London.
Good, I'm with you, Christina. Excellent. What are you reading at the moment?
I'm reading, probably lots of regulations, but a book it's called Weapons of Math Destruction by Cathy O'Neil, about algorithms.
Do you recommend it?
Yes, very good.
Okay, fantastic. Talking or listening?
Listening.
Listening, and favourite app?
I should say Poloniex, but also Law 360.
Fantastic, thank you. Mike, London or New York?
London, definitely.
Excellent. What are you reading at the moment?
Blood Meridian by Cormac McCarthy.
And talking or listening?
I'm definitely a talker. So,
And your favourite app?
I'd go with Twitter, honestly.
Excellent, excellent. Good bit of reach. I hope you'll be tweeting today. And Nimit, London or New York?
New York.
And what are you reading at the moment?
Meditations of Marcus Aurelius.
Meditations of Marcus Aurelius. Okay, so something really modern.
Yes.
Talking or listening?
Listening.
And favourite app?
Probably Apple News.
Okay, excellent. So starting with you, Nimit, leaving the microphone with you. Now, I think everybody's probably familiar with the Gartner hype cycle, and I've got to say I've studied a lot speculative bubbles and also how to write a PhD, and they also follow the Gartner hype cycle. Start with the innovation trigger, the peak of inflated expectations, then you go to the trough of disillusionment. We wind our way up to the slope of enlightenment, and finally we hopefully reach the plateau of productivity. So Nimit, where are we with blockchain at the moment on the Gartner hype cycle?
I would say, as someone who is sort of in a unique position, because I would say probably down in the ditches right now, to be honest. There was the 2017 where things were overly hyped up. I think that made it a lot harder for ideas and companies who are trying to do more legitimate things than just do an ICO. So I think that hurt the industry a lot and possibly set it back by at least 5 years, in my humble opinion. I would say now the positive impact of that is that real use cases are coming up, and a lot of the fake or the less useful stuff is probably going to fall by the wayside.
And Mike, do you agree? And if so, I've got a further question. So what's your position? Do you agree with Nimit?
I agree. I think one of the issues I would add to that is the regulatory uncertainty, which is kind of causing reputable projects and good use cases to kind of not be able to move forward. I think the SEC in particular has taken steps to give guidance, but there's still a lot of questions to be asked that kind of leads projects and reputable teams to not really be sure what to do and then fall back on conservative approaches, which sometimes affects the vision of the project. So
So do you think it's part of the SEC's job to assist, and regulators in Australia, the equivalent is the Australian Securities Investment Commission, do you think it's their job to help to support innovation, or is it more important to protect consumers and investors from scams?
yeah, I think the organic statute basically comes down to that they're supposed to be protecting retail investors and avoid scams in that sort of way. I think at the same time, in all statements they make, and kind of their mission driven by the idea of not trying to stifle innovation. And so I think they're trying to balance those two. I think the guidance that they gave recently, I applaud them for taken that step, but it leaves open a lot of questions that don't allow projects to move forward. And on the corporate finance side, where they're supposed to be giving more guidance when it comes to what projects should be doing, there's concern and reservations and delays, which are leading projects to kind of take their own steps and then kind of ask for forgiveness after the fact, which is, again, creating this issue of ongoing regulatory uncertainty.
Okay, and Christina, what do you think is going to be the big step that could be taken if we were going to move towards the plateau of productivity?
I think one step that we've already taken to get there is kind of the end of the ICO boom and falling off that hype cycle. I think moving towards productivity, the big step will probably be for regulators to entertain a certain amount of uncertainty in their sort of mission. You know, like Mike said, investor protection is the most important thing for them in terms of the mission of their statutes. But I think, you know, allowing businesses and individuals who are building things who don't have the money to comply with these onerous regulations, that's going to be really what allows, at least in the US, you know, new businesses and new inventions to get off the ground. And I think we're seeing that those inventions go elsewhere to other jurisdictions that are friendlier if the US isn't going to be open to that.
So just keeping the mic for a moment, you've just talked about this idea about protecting investors. Is the SEC underestimating the sophistication of certain types of investors who should just be allowed to go forth and spend their money as they choose?
I think it's definitely a personal preference how much you think the SEC should exercise oversight, but I do think that what they're doing is shooting for kind of eliminating fraud instead of sort of reasonably curtailing it, and allowing a certain healthy amount of business to occur where fraud might be a byproduct of that. That occurs in regular products, like you might buy a software license and the software doesn't work, and so that doesn't mean that it's a security necessarily. So I think that kind of the desire to eliminate fraud and eliminate scams is really what's coming out from their recent actions, and instead of allowing innovation to occur, it's been too limiting.
Yeah, okay, and for Jeff, just talking about this whole idea about trying to eliminate fraud, isn't that just a ridiculous proposition? And so that should be just set aside as a concern or as an aim? Because if you think about fraud within the banking system and illegal downloading of music, they're on either ends of a very, very big spectrum of just day-to-day fraud. That just happens all the time. And yet we don't eliminate the music industry or the banking industry. Do you feel as though there's some special sensitivity that's arisen in relation to crypto and innovation that is being treated a little too heavy-handedly, perhaps?
No, I disagree, actually. I think that fraud, I mean, like any business, as people have pointed out, the fraud can be a component of anything that occurs. I think that the SEC's, in particular, position on crypto is that you actually sort of, the sort of exception eats the whole, right? If you take the position that people who are investing in crypto don't need any of the sort of standard investor protections, that's just, you've completely just breached the floodgates to any sort of regulatory regime that says, hey, we want people to be given some level of information, some level of disclosure regarding the things that they're involved in. So I don't think, and so if you look at what happened with the ICO boom, it was clear that this is a sort of, it was functionally enabled, that you had fraud that was sort of severely enabled by the way that the system operated and the way that people could simply evade. It sort of proved out the need for securities regulation. It proved out the need that when you invest money, you should know what the people who are receiving that money intend to do with it, what their financial interest is in what they're going to receive from you. And so I think that the fact that as the boom exploded, people simply were sort of grabbing the tokens and then selling them to the next party in a way that became this sort of game of musical chairs that I honestly don't think that you could have, the regulator could look at and say, I'm okay with this happening because these are people who are making their own decisions without compromising the entire regulatory structure of investor protection.
Okay, so Just to get my voice back on the recording system again. Thank you, Jeff. I'm going to pass it back to you, Jeff, because I want to just have a little bit of a chat about going to an auction on a Saturday and buying a painting. So this Saturday, if I wanted to, I could go to an auction anywhere in Boston and I could go and buy a really bad $50,000 painting, and as long as the vendor, as long as the auctioneer or the auction house doesn't in any way misrepresent the origins, and let's just assume they're not saying it's a Picasso. I'm just looking at it thinking it's by a nobody, and I think it's gorgeous, and I'm hoping there's a greater fool than me. Now, the greater fool principle is what drives a speculative bubble. It's the idea that I buy the bad painting for $50,000 in the expectation that there'll be somebody stupider than me who'll buy it for $75,000. Now, for me, most people buying those crypto tokens on those ICO programs or projects or off those white papers, we're just operating on the greater fool principle. And I don't know why they can't. Why is that so bad? Why does the SEC think there's some special relationship that we have with crypto that we don't have with the bad painting I'm going to buy on Saturday?
You've hit the sort of the fundamental legal point here, is that what is a security versus what is a commodity versus what is any other speculative item, right? I mean, it's entirely clear whether it's in a painting or an apartment that you buy hoping to flip it, that doesn't make it a security. So the question that has come into this particular area is, why exactly would we treat this, your question is, why does this token I'm buying online treat it different than the painting? And I think the answer is, there are rules and regulations around auctions and auction houses and how they work, and we fit them in a regulatory regime. What crypto effectively came out of the gate saying was, hey, there is no regulatory regime that applies. There's commodities law. So if you were to do what you're describing with an orange juice future, you would face the CFTC and the question of how they manage how people who buy commodities and intending them for resale are able to engage in their business. So there is this, regardless, I think what happened with crypto was the position was, well, it didn't fit in any of the various categories that we've built up to regulate these type of behaviors. So let's just say no rules apply, which to me is the same as saying, hey, I don't have a line item on my budget for this thing, so therefore I have an unlimited spending I can do on it. It just doesn't make sense.
Okay, so passing the microphone to Christina and assuming my voice is loud enough, what Jeff has just said is that we've got a scenario in which, because crypto came out of the gate and didn't look like anything we really knew about, no rules applied. And I think one of the interesting questions I want to raise is, to my mind, the rules will always apply as long as you can characterise the expectations of the purchaser. If you can say the purchaser has a certain expectation, there will always be a court that's willing to listen to that complaint. So do you think that that should be just driven by litigation? The regulator should just let it be for a few years, and this was raised yesterday in the panel. Let it all be and see what the litigation says. Let the courts do their work with the traditional laws about purchaser expectations. What do you think about that?
Yeah, I think that makes sense. I think it's sort of what they've been allowing to happen with the sort of regulation by enforcement approach that the SEC has taken, rather than kind of passing rules that you can't then repeal as easily. I do think that sort of what the product looks like and the ability to see that this is a painting and I know what it looks like and I've seen one of these before, versus a token that works on a blockchain on a network. There is sort of, with the latter, there is this information asymmetry between the purchaser and the business who is creating the token and creating the business and has the financial statements and has kind of the understanding, the technical knowledge, that I think can be resolved by sort of requiring these companies to produce helpful and clear disclosures, which is really the point of the securities laws, I think. And so, maybe it's not that we need something that looks like IPO securities registration, but I think that we do need other requirements above and beyond sort of litigation and regulation by enforcement. I think we need sort of rules that require businesses who are building something, who have information that their purchaser inherently just doesn't have the ability to access. I think we need to require those businesses to give information to their potential customers. And if that's something that once they do, it looks enough like a painting or it looks like a tool that they can use and they can see that, then I think that's the time when the law can stop sort of protecting and allow the transaction and the business to occur.
Okay, so I've been secretly playing blockchain bingo, and Christina just won. You get the book.
Oh, why, thank you.
That was the first mention of the B word on the panel.
Oh, really?
That's why you got the book. Sorry, gentlemen, but I didn't give anyone any hints. I didn't tell Christina, by the way.
No.
But I've got a question for Mike. Mike, do you think that the fact that this is such a disintermediated and also decentralized sort of global phenomenon, and sometimes a little difficult to pin down jurisdictionally where things are happening, that it's problematic that we've just got regulators all over the world who've got their own particular jurisdictional spin? Or is that something we can work with even in the crypto blockchain world?
I think they're forced to work with it. I think it's a great point of it's a novel issue in crypto and in the way of how it's applying. And kind of responding to what Jeff was saying, I agree. A lot of projects came out saying, well, we don't fit into any of these buckets. So therefore some rules not apply. But a lot of times their agency's approach was, well, we all apply. So you have situations in which FinCEN, as a currency, is saying that you are a money service business. You need to register, do know your customer, anti-money laundering regulations. And at the same time, if you are a currency, you can't be a security that is exempted out of the Securities Act of 1933. So there is this bubble where the projects themselves don't know which way to go. Now, when it comes to kind of different jurisdictions, I think a great example of that is New York, where a lot of projects just moved out of New York because of a state-run regulatory regime, which was difficult for them to deal with. But I think that is also a problem with the age of the internet, and where projects aren't local anymore, they are global. And so there is at all times having to worry about not only the state and the country you're in, for example, or the province, but also where your consumers may be and what those regulations may be there, because regulatory fines may destroy your business, especially when you're startup phase.
So Nimit, just talking on this topic about globalized or localized legislation, in Australia we have a particular kind of federation. Our Federation of States has one regulator for everything to do with corporate and securities regulation. We can't forum shop and go registering in Delaware just to get that little tax haven, or Florida for estates taxes and that tax haven. And there's many, many tax havens in the United States in history and currently. We don't have that wonderful privilege in Australia. But what we do have to do is plug into the rest of the world's legislation, and we find ourselves more and more in Australia where we don't have a general right to privacy in Australia. It doesn't exist. Privacy didn't exist really as a thing in Australia until about 30 years ago. But what we're doing now is just deferring to the GDPR. Because it's stricter, we're going to have to comply anyway, and our privacy regime has become pretty obsolete now that GDPR exists. What do you find that you're thinking similarly in relation to GDPR and certain other laws that govern the way we're dealing with online and computational law?
Definitely. And here in the US, there's the CCPA in California, which is in some sense even stricter than GDPR. For our specific use case, elections and voting, we have an even higher burden in terms of privacy and data security. So definitely that is top of mind. And then sort of touching back on the jurisdiction question earlier, for us, that's also a very interesting question, because elections, in a sense, have been traditionally the most centralized use case ever. And now that there is some movement to somewhat bring more transparency, decentralize them, at least at the jurisdictional level, it creates this interesting question: would a jurisdiction let us conduct an election on the Bitcoin blockchain or the Ethereum blockchain, where you really can't control where the nodes are running? And so how do you get that sense of confidence that even if half of the servers are running in potentially unfriendly parts of the world, that maybe your election's not going to get compromised? So I think you have to look at jurisdictions from a use case by use case perspective. There isn't going to be a one size fits all formula for everybody.
And just keep the mic for a minute, because you've been exploring this idea about running online elections. And one of the things that I find interesting when we take a very human experience and then put it online is, at think sometimes we are all in danger of holding the technology up to a higher standard than the human version of that particular process. How would you say that that has played out with the work you've done with trying to do elections online and voting systems?
So it's been the single biggest hurdle we've faced. The opposition we face is exactly like you said. There is this perfect vision of a perfect election system, which doesn't even exist in the in-person version right now. And so we are constantly compared against that. And I think the challenge is to bring to the fore that we may never get a perfect election system ever, but we can get something which is better than what we have, and take into account in most cases, more than half of the country is in voting. So do you want to stick paper on that and use that as probably the biggest form of voter suppression, or offer alternate technologies to people who don't want to go vote in person or can't go vote in person for whatever reason? So I think, yeah, it's a big challenge. There is this idea of perfection, but then we've been trying hard to bring people to reality, and especially now with the proliferation of smartphone technology. I mean, you could make a case that your smartphones are more safe than your average computer. And so why not experiment with smartphones when literally 80% of the world now has a smartphone?
So Mike, thinking about what Nimitz just said, he's just started talking about this whole idea of everybody's got access to the smartphone, and yet you may not have access to actually attending personally a voting booth. And so suddenly you've brought the electoral process to you personally, rather than you having to go to the electoral process. I think now in 2019, we talk more and more about governance systems, transparency, trust, and also inclusion. Do you think that's the future for this computational law environment? Is that going to drive us forward, or are there more traditional concerns that are at the fore? Because I think inclusion and transparency have become really strong torchlight conversations everybody wants to have? Or do you think we need to think more about risk and trust when we're talking about how we're going to work with computational law?
Yeah, I think that's a great point. I think just off of that, I think two of the things that brought me into blockchain and kind of like cryptocurrency projects is the idea of kind of inclusivity of what the project can be, and the idea of making it be a peer-to-peer sharing economy where you don't need to rely on these third parties to do certain actions. I think moving forward with this compute law and kind of this structure to it, I think you face one thing is the risk involved of the rollout of one issue, but off of that being the reactionary tendency of people in these kind of projects where if one flaw occurs, it could set back the idea of this progress moving forward decades in that kind of process. So there needs to be this sort of measured approach, and I think you could probably cabin that to risk in the way of how to make it work, but also how to have people to have buy into it, and then also believe what they're seeing through this immutable distributed ledger and like this proof of work structure is exactly what they would have seen if they were in person talking to that individual or checking the box in a voting booth.
And so you've just mentioned this proof of work and peer-to-peer, the distributed ledger. That's all about the automation of trust, putting the trust into the actual on-chain rather than leaving it with a third party. Do you think we're close to being able to do that, or will we continue to need the trusted observer, at least as a human entity? Where are we with that, do you think? How are we tracking?
I think that's a great question. I think, me personally, I think it comes to like you using certain use cases in certain instances and kind of getting that yourself of seeing the record play out. I think we are close. I think the issue is for the community at large of whether or not you'll get uniform buy-in to these projects is probably further down the road. But I think in certain specific use cases, the results are clear. And so the more and more people who use the product and kind of see that process, there'll be more and more buy-in in that way.
And Christina, one of the things, just thinking about blockchain and the way that services are going to be provided in products, one of the things, the expression we use in Australia is trying to distinguish between whether you're going to deliver a Toyota Corolla or a Rolls Royce. I think in America it might be something like you're trying to deliver a Buick or a Ferrari. Is that going to work as an analogy? I'm trying to come up with a really, really good, reliable family car versus the luxury vehicle. And in Australia, everybody wants Rolls-Royce litigation or Rolls-Royce legal services, but they can't afford it. What they can afford is a Corolla. So I just think, is that something that we all need to have a little bit of a reality check about and understand that there's a lot of people who are missing out on really good investment services, investment advice, legal services, legal advice, but we could deliver at a Buick kind of level something that would suit more people. And we can do this online. And so we need to stop expecting people to build the Rolls-Royce or the Ferrari and just go, well, actually, everyone knows their appetite for risk. I mean, what do you see with your clients and day-to-day? What's your experience?
Yeah, I think just in going through sort of being in this industry for a while and seeing all the new sort of blockchain kind of projects that have been built over time, I think that transparency and trust have really become much more of a something that a consumer looks for. And I think that what will be helpful is maybe not providing a Ferrari of, a voting system or some other type of system, but maybe an auditable system. So something where, even if you don't understand kind of the inner workings of the technology, I think the problem that needs to be solved is that the everyday consumer can have sort of access to a validation or a confirmation that the system is transparent and the system is doing what it says it's doing. Just a quick example, there was a very interesting blockchain project that came out a couple summers ago called Bancor, and it's basically kind of has these smart tokens, and the way that the network works is, I believe it's built on Ethereum, and there was a sort of a breach that occurred with respect to the Bancor network about a year ago. And what happened was everyone realized that the people who run the network, like the individuals who started the business, are able to actually sort of hit a kill switch and freeze the network and make sure that that didn't happen. And so rather than having a fork like you did with Ethereum and Ethereum Classic when the DAO was hacked, you have this kind of kill switch centralized focus where something that was presumably a distributed decentralized network is now able to sort of be controlled unilaterally by the individuals or the entity who built it. And so I think that sort of understanding of, I don't have to go in, as a lawyer who doesn't code and research the smart contract code and the Ethereum code of, this project, but instead I have some sort of way to audit and trust what I am looking at, and that thing will be transparent and fair.
Okay, so passing to Jeff. What Christina's just been talking about is this moment, either kill switches or forks, where you say, we need the human in the loop. Something's occurred, there's been an event, and we need to go, that's when you now insert the human to do their bit to give satisfaction, trust, and a bit of comfort to everybody that this isn't gone completely crazy and rogue. One of the things we're doing, I'm the lead author for the International Standards for Smart Contracts, and I'm on the Standards Australia team, but that's the work I'm doing internationally. And one of the things we've come up with over the last year, which is sort of my idea, and I'm applying it to weapons, algorithms, and then also smart contracts, is the idea that we should actually all work out how much autonomy do you want depending on how you're using the particular system. So is that anything that resonates with you, that actually all of this autonomy that we can build into a blockchain network, whether we're going to have forks or whether we're going to have kill switches, should be determined up front so you have transparency and a bit of clarity and predictability, but also it should be based on what the use case is. Does that resonate with the kind of work you do, or do you feel there needs to be a little bit more autonomy and less human in the system than this would suggest?
No, I think one of the things that we've been going around here is this question of, what standards is the technology held to? And the idea that it's held to fairly high standards is because when this technology is released into the wild, the errors that you get a sort of Sorcerer's Apprentice type situation, right, where the music plays and all of a sudden there's a million disasters going on everywhere. And so the question, really to me is how reproducible, what is the frequency at which transactions are occurring? Because if you build a system that has a glitch in it, and it doesn't have I think we've seen that this is kind of where we are with talking about forks and other ways of handling kill switches, is what do you do when this is broadly disseminated? And so, of course, with a voting system, nobody wants to find out 6 months after the election that, whoa, there was a glitch in the technology, we actually counted the votes wrong. That's an absolutely 100% unacceptable result. And so, you know, to me, a lot of this hinges upon, and where the human element needs to come in, is the fact that you have to look at what is the consequence of error. And I think that when you go back to that question of how you get the human back in there, it feels like you sort of retread the same territory we've always had, which is, okay, well, what is that intervention? Is that intervention centralized? Is that intervention consensus-based? And all of the rules for figuring that out, those aren't, you know, the technology is what enables the incredibly rapid iteration, but you still need to solve those fundamental problems about how when human beings put a network together, there needs to be a way in which you ensure that that sort of accomplishes the goals that people have sought to accomplish. And so, you know, turning it around on you a little bit, this question of, would you think differently about, you know, back to that painting you offered, if you could do that 1,000,000 times over, if that painting was being bought and sold 1,000,000 times over versus just a one-off you at an auction, that changes how you think about the regulatory aspects of it, and maybe in a not entirely sort of theoretical, coherent way, but in a way that says we have to deal with those problems differently than we deal with things that are by their sort of technical or physical limitations one-offs.
Yeah, and I think that's a very important question, because when we talk about scams, scammers often want to just take a little bit from us.
Yeah.
So little that we either don't notice or we don't litigate. And what they do is they do it on this multiplied level with all those multiple paintings that may be fakes or really bad, and they make an enormous amount of money. So yes, you need a class action to bring any kind of restitution, but how do you even find who the scammees are? The scammer probably gets away with it a lot. And this is why I'm really interested in the way regulators are now deciding how to deal with these hacks and nefarious actions. They're just going for the platform providers. And that's what the GDPR is, and there's other examples. Just mindful of the time, can I ask, because we've got so many JD and LLM students in the room, I wanted to ask the question, and I'm sure there'll be lots of other questions we can get from the room once we hit the time for questions. I wanted to just run back down the panel and ask how you think this computational law and blockchain future is going to change or impact the legal profession. You can speak to your particular practice or the wider legal profession.
I think from my perspective, this is all a ways out, right? I mean, I think that what we're seeing is, you know, there's been the initial rush, and then now the actual technology has to be employed in ways that are successful and reproducible. I look at what I do on a daily basis, and, you know, obviously I'm biased, of course, but there is an element of sort of application of judgments to novel scenarios that I think by definition can't get reduced into an algorithm, because you're always asking the question of how do you apply this unique, you know, innovation to something that is, you know, that has an older system that is in many cases not, you know, engineered specifically to move slowly. Like litigation, courts as a rule, is what I learned in these hallowed halls, they want to move slowly because it's better for the legal system to protect its own sort of stability if it goes very slowly and causes litigation to be a rigorous process. So you combine that with the fact that certain of these things are just going to move fast, you're always going to be running out ahead of a bunch of the constraining-based systems. And then the question becomes, for the lawyers who do this work, how do you match that sort of the risk tolerance to the likely outcome of the application of new technologies to regulatory regimes? And that, I personally don't see as something that is ever going to be reducible into a smart contract and leave me out of work. And if it does, it's going to be by the time I'm long past the age where I was out of work anyway.
That's a terrible out, Jeff. I'm sorry. That wasn't a part of the question. That was unresponsive. You'll strike that from the record. Christine, what do you think?
Yeah, I agree. I think that a huge change is sort of, well, you know, we've seen it with the internet, but I think it's kind of the jurisdictional issue in how really now no longer is information just kind of transcending borders and physical locations, but also now sort of we can have self-executing autonomous contracts and sort of any type of financial transaction, there's literally no physical nexus to any state or jurisdiction anymore. And I think you see that with some of the really adverse reaction to the state money transmitter laws that are kind of capturing crypto exchanges, and sort of there's a lot of interpretation there that your business falls within Alabama's law, for example. And I think that the removal now of really any physical aspect that occurs, you're not even going to pick up a money order or a check from Western Union in this state. I think we're seeing that, and even on the securities level, sort of the international transfer of tokens, if you're gonna have something that's deemed a security token, move between a UK resident and a US resident, and just sort of the borderless, boundaryless sort of existence of these things, I think jurisdictionally is gonna create really interesting changes.
Yeah, I think that's a fantastic example. And Mike, what do you think about the future of the legal profession and all of this change?
Yeah, I was just gonna, Christina stole my entire point. So I would say the jurisdictional aspect is really interesting to me. I think one thing I would add to it is the fact of when it comes to the corporate side and the regulatory review when deals are occurring, is I'm seeing more and more of the aspect of retaining counsel from various jurisdictions around the world, in which it's turning the second habit of just putting on the phone like Singapore counsel, European counsel, Swiss counsel, to kind of like basically turning more and more of a project and corporate disclosures and kind of deal terms are becoming an international review just because of the kind of the structure of things. I think just another point I would say is it's also starting to have regulators kind of think through how they apply strict liability in certain situations. One would be if you wanted to cut out the United States from, say, your offering of tokens because you're trying to avoid securities laws, and you want to block VPN addresses so no American computers can access it. What if someone gets outside of that? If an American citizen is still somehow gets onto and purchases your token, you just violated American securities laws. You did everything more in the steps that you needed to do and took additional steps, yet that was approached. So I think that's kind of a step that will become going through from a regulatory perspective is how do you apply these where it was a black and white line, now going to this gray of figuring out, well, what do we truly mean here when it comes to reasonable precautions taken?
Yeah, that's fantastic. Thank you. And Nimit, what do you think? I mean, this is great from a voter perspective to ask about this question of changing the law, changing the practice.
I have mixed feelings about that. I'm not a lawyer, so pardon my opinions on this, but I'm a little bit scared because I've been reading some papers on how now AI is filtering into the blockchain space. So it is conceivable in the future that for starting with rudimentary law cases, it might be a algorithm or a robot which is determining the outcome of the litigation, which is a scary thought because, as Jeff pointed out, law has always been somewhat of not a yes or a no question. There's always somewhat of a gray area. And if AI becomes advanced, which someday it will, if it's not already there, then we will see the scenario of automatic algorithmic adjudication, at least for rudimentary law cases, where that leads to, it's probably a scary thought. So that's my layperson opinion, not being from the legal profession.
That's enormous value because it's lawyers stop thinking about what clients expect. We have nothing to do anymore. We lose complete perspective. So it's wonderful to get your view. I think we're up to question time. Is that right, Alice? Should we put it out to the audience? Has anybody got any questions for the amazing panel we have here? Yeah. Question.
Thank you. Where's
This gentleman over here.
Thank you all for coming. This has been really awesome. I guess my question is sort of for everybody, but maybe the kind of like regulatory counsel or just people who work with clients, Jeff and Mike. To what extent is your job, like at this point, educating regulators versus sort of educating your clients about what the regulations are and what they have to do? Like what kind of, if you could draw a percentage line down the middle, how are you sort of dividing your time on that task?
Yeah, really good question. You know, it's a lot of both, especially in a company that is not, you know, huge. We have like a 15-person legal team, which is, you know, it was like 3 people 5 years ago, so it's definitely better. But there is a lot of educating. I think that actually now we're sort of entering a phase where we don't have to do much educating. I think that also is because there are, you know, bodies like Coin Center, for example, who is really a policy type of body that's dedicated to educating regulators. But early on, especially when Circle was first applying for our money transmitter licenses in all the 50 states, we really had to explain what Bitcoin was. I mean, we really were starting, it was like 2014, and it was from the very beginning. And the other aspect was law enforcement and sort of getting subpoenas from them and, okay, give us all the information you have on this type of transaction. And they would just want kind of dumps of information. And we had to really thinking about customer privacy, but also just kind of explaining to them how things worked with the Bitcoin blockchain and giving them a way to sort of focus their investigations and their inquiries. So there's a lot of that. It's a little better now, a few years down the road. But there's a lot more, I think, educating the business on the regulations, because as the business grows and as sort of the regulations become more complicated, even though, I guess, more certain and therefore more complicated.
Any other questions? Another question? Yes?
I sort of understand that you're all not technologists and lawyers, except for you, Nimit, but I'm shocked how easily people who spend most of their life on blockchain, on decentralized type of way of thinking, and I understand it's a very difficult way to switch your thinking from centralized to decentralized, because that's how we live our lives, that's how we grow up, how easily you're willing to switch to some kind of centralized control of somebody flipping a switch. Most of you being lawyers, I'm curious if you thought about that, since you're so easily willing to flip a switch, what if the children, wife, or whatever significant others in their life of whoever is able to flip a switch gets kidnapped and get blackmailed?
So, yeah, I'm a lawyer, and my experience with kidnapping and kidnapping and blackmail, they're just crimes. So on or off chain, still a crime.
I think, I mean, it's an interesting question. To me, the answer, it goes back to this human introduction of a human element. And I think the theme that we've heard here is a purely automated system is never going to, regardless of the degree of transparency, has an amazing hurdle on trust. And so the question, and this is what I take from the research you were discussing, which is, it's a given that you're going to need some human intervention. So on any of these systems, for them to function properly, maybe it's a smaller amount, maybe it's a greater amount, maybe it intercepts the process at different points. But I mean, to me, it's not about like one person with control or a kill switch. And it's more the fact that in order to introduce that human element that gets away from 100% technology, you are back in the world of people. And whether it's a kill switch, whether it's an override through some other function, all of the things that you're talking about, well, there's crimes that are committed by people against people are sort of reintroduced. And so it's just more like the technology does not escape the problem, I guess is what I'm trying to say.
I think it's also really important to remember that the code is written by humans, and when we start allowing machines to write the code, then we have moved into a domain the humans still need to understand. Otherwise, we've lost agency in our own world. I know that this world is populated by other biosystems and other animals, and I accept that, but I still contain a lot of agency in my role on this planet, to ensure that charity goes to the right place, to ensure that there's succession for sustainable development, and that we take a very, very strong interest in the future of the planet. And I think if we're not watching the code, how do we continue to share wealth, care about charity and welfare, care about the poor and the vulnerable, and they will always exist. And any one of us can be inherently vulnerable, or we could have vulnerability imposed on us by circumstances. And those two are very important in the law, to understand when you're inherently vulnerable or you're under the circumstances vulnerable. And I don't think we should leave the code to machines. I think that's a human experience. And I think in the end, the law is a social science. And what we care about most is the social welfare of those around us and the future of generations. So the pure automation without the human in the loop should be avoided, particularly if you introduce AI where there's any self-learning. If it's programmatic AI or human remote-controlled AI, I have a little more comfort. But I think it's something to keep in mind when we talk about the human in the loop, that actually these are human systems, and that's what we care about when we talk about the law as lawyers. Another question? Any other questions? Well, yes. Go, Amy. You want to ask one?
I sort of wanted to hear what the biggest issue you're facing in the office at the moment right now, so that students get a chance to see what you're facing day to day. So the biggest legal issue, yeah.
So let's start with Jeff.
Sure. I mean, personally, the biggest issue I'm seeing is watching venture capital adjust to blockchain and watching investors, the long-term successful VCs who've always been chasing innovation, watch them try to figure out how to maneuver into this world, which presents a very different challenge than just about every sort of new innovation of the past, as long as VC's been around, because there is now a question of, what if owning shares of the company, which is what VCs have always done and relied upon to produce value, doesn't actually create any value because the company produces some sort of crypto token, and that creates all the value. So now the investors own shares of a company, but they don't have any way to access the value. They made the right bet, but they don't get the reward. And they're spending a lot of time thinking about how to make those investments in a way that covers off that problem.
Yeah, that's a really interesting issue. I think my sort of overarching thing that I'm preoccupied with is, we Circle acquired this exchange, Poloniex, last year, and we've had a lot of trouble kind of deciding what is this thing that we're going to offer on our exchange, and is it safe to offer it under U.S. law from a U.S. entity? And so I had to kind of go through when the first kind of SEC report came out and figure out a framework for applying the Howey test, which defines what is a security, to the tokens and the products that we want to add to our exchange. And then similarly, when you enter into sort of proof of stake and getting involved in staking and doing governance and getting sort of Stellar is one of the coins that offers inflation. What are these kind of ancillary payments? Are those securities? Are those investment funds? How do you really classify what these things are? And so trying to fit that into a framework for understanding the business risk that we're taking on.
I think kind of more specific, but I think in 2019 or within the probably next 2 years or so, there's going to be a case, going to be a test case of whether or not, like the application of Howey to legitimate non-fraud token sales and token projects that are legitimate use cases that's not in question, and whether or not how these steps apply. And so far, we've had a lot of guidance, a lot of statements, a lot of settlements against small projects that weren't really doing much. But noticeably, there has not been any of the key projects that we talk about a lot and which everyone knows. None of them have been signed up to any of these regulatory regimes. They're still in this gray area. And one of those